Section 7 of the 6th schedule requires us to construe all laws immediately enforced before the effective date with the alterations, adaptations, qualifications, and exceptions necessary to bring them in conformity with the Constitution. For purposes of Section 7, all laws include the former Constitution, which must be read in a manner consistent with the Constitution. Taking what we have said into account, we hold that Section 9(2) of the 6th schedule amends or modifies the provisions of the National Code and the Constitution Act 2008 to the extent that general elections can be held if the coalition established under the National Code is dissolved and general elections are held before 2012. We are also of the view that insofar as the positions of President and Prime Minister are saved by Section 12 of the 6th schedule, Section 6 of that Act is amended or modified to exclude the possibility by one coalition partner withdrawing from the coalition by resolution of the highest making organ of that party, by preserving the position of the President and the Prime Minister until the next general elections. Section 6B of the Act must be read to mean the President and the Prime Minister must agree in writing. We therefore find that if the coalition is dissolved in the manner provided in Section 6B of the Act, that is, if the President and Prime Minister agree in writing to dissolve the national coalition, then the general election shall be held in the year 2012. And in terms of Section 9(2) of the schedule, the election for the first county assemblies and governors shall also be held on the same date during 2012. It follows that the definition of an expired term under Section 10 of the 6th schedule must include the words, quote unquote, upon dissolution of the national coalition in accordance with the terms of the National Code and the Constitution Act 2008, in order to give full effect to the words of Section 9(2) of the 6th schedule. We agree with Counsel for the IEBC that in light of the authority and powers conferred by Article 88 to the IEBC, of the Constitution, it is the IEBC that must conduct and supervise, IEBC, that will fix the election date for the first elections under the Constitution. The IEBC is an independent body, and in line with this mandate, it shall fix a date once it satisfies that conditions and arrangements that ensure a free and fair election have been met, but within 60 days of either of the two events referred to in paragraph 164 above. We are conscious that our findings may be unpopular with a section of Kenyans who have preconceived notions about the elections. But we hasten to remind Kenyans that our undertaking is not to write or to write the Constitution to suit popular opinion. Our duty is to interpret the Constitution in a manner that remains faithful to its letter and spirit and give its effect to its objectives. We are cognizant of the fact that the 6th schedule was a compromise political package arrived at between the various factions of politicians to ensure smooth passage of the Constitution. We believe that we have discharged our responsibility and call upon all Kenyans to continue the task of implementation of the Constitution and nation building.
Our position as CIC is twofold, and we stated this even in our published statement just before the end of the year. And what we said we needed is two things. One, an affirmation that when there is a legitimate issue of interpretation of the Constitution, the final arbiter has to be the court. And so from our perspective, the court has pronounced itself on the date of the election, and for us, that is the Constitution that is the living Constitution. That is a Constitution in practice, that this is the body that is mandated by the Constitution to determine that issue, and it has so determined. The second thing, of course, is that in practical terms, it brings to an end, or ought to bring to an end, that particular aspect of the public debate, public discourse on what the date of the election is, so that we can proceed with those bodies that are charged with the responsibility of preparing for that election will proceed with that, and the rest of us will proceed with the process of overseeing the overall implementation of the Constitution.
It's a very well-written judgment, very very clearly reasoned, and I think it is for mwananchi. They can read it and understand it, and they don't need any other lawyer to read it for them and tell them what the judges reasoned and what they have determined. And I think, to me, this is a celebration for Kenyans, especially in the light of where in the past we couldn't understand the judgment. Now we can understand the rationale, and it meets the international standards. So that's what I take as a very good judgment for me.
And there's clarity now, and I think the courts have any areas which were not clear. There is now clarity as to when our next general elections can be held, and they have said clearly that the term is 5 years and until January 2013, and in the event that the two principals decide, again they have added even more certainty and clarity, because they have said the two principals can in writing agree on a date before during the year 2012. So I think now there's clarity, and it provides a good news for Kenyans. Very good judgment. We are thankful to the bench that deliberated on that particular case. Yes. Thank you.
First, I wish to applaud the judges. I'm happy that I also wish to applaud Honorable Mwau for taking this case and for challenging that particular issue. The Professor Guy and the ICCRG, whom I was representing, the argument has been a correct interpretation of the law. But the more important thing is that I believe this is without, and I'm also applauding the judges, but without taking anything away from them. I believe that the first route, the possibility that the election may be conducted in 2012, is purely academic. It is academic for the simple reason that they said, whereas the two principals can dissolve the national coalition, there is no power to dissolve parliament. Section 58 of the old constitution was preserved. Section 58 said to do a general election, parliament must be dissolved. Since parliament dissolves in January 2013, then there is only one route. The elections will be around March 2013. The other route of 2012 is purely academic, although it is in the judgment.